Or in my understanding is that polygamy is already outlawed in this country for most communities, barring the Muslim community. It is the 1937 Shariat Application Act that allows Muslims to marry more than once, because under this, marriage is something which is completely governed by personal laws, which is the Muslim customary laws. You can have up to 4 wives, and it is completely uncodified. It has run as a customary practice ever since. The second key aspect is also the Dissolution of Muslim Marriages Act and the customary practices of talaq which are prevalent within the Muslim community. In the entire ambit of personal laws, Arunima was talking about the 6th schedule of the Indian Constitution, where the scheduled tribes are exempted particularly. That's a huge portion to look at, because that was something that the law panel had also suggested. Arunima, is there anything in particular that they talk about the Muslim personal law? And I ask this to you for the simple reason that Muslim personal law is the outlier in all the personal laws. It has not been codified, it has not been rationalized, it runs and is governed by customary practices. All right, we'll try and connect with Arunima. She continues to be with us on the broadcast. This is a voluminous document that has been presented on the floor of the House in Uttarakhand Assembly. We'd have to wait and watch how this affects the Muslim personal law. One has to make this abundantly clear that most of the personal laws in our country have been rationalized ever since independence, including the Hindu personal law, which is now completely statutory in nature, and all the aspects of it, even which that conflict with the religious principles, are now in the line of Constitution, which is Article 14, equal rights to men and women when it comes to inheritance, which was not a factor of the Hindu personal law. Muslim personal law, as I argued earlier, is something which has been governed by customary practices, especially marriage, divorce and inheritance. Even today, under Muslim personal law, a girl who has attained puberty, even if she is under 18 years of age, can be legally married, and this despite child marriage being an offence in a country like India. Are all of those critical aspects really dealt with in this draft that has been presented on the floor of the House in Uttarakhand Assembly? 300 pages plus cannot be a law. It is a draft that has been presented. Over that draft, there would be wide discussions that will happen, and we'd have to wait and watch what exactly is it that the Assembly eventually decides. As expected, UCC has generated a lot of political reactions across party lines. Listen in.
सर, आप क्यों विरोध कर रहे हैं यूनिफॉर्म सिविल कोड का? ये तो कह रहे हैं कि समान अधिकार होना चाहिए, समान कानून होना चाहिए देश में।
देखिए, मैं विरोध अभी नहीं कर रहा है, मैं आने के बाद बताऊंगा आपको। अगर इसके अंदर ऐसी हिदायत है जो कुरान शरीफ के खिलाफ है, हम जो कुरान ने हमें हिदायत दी है हम उसे फॉलो करते हैं। हमें कुरान शरीफ ने हिदायत दी है कि हम अपनी बेटियों को पैतृक संपत्ति में 14.5 साल से हिस्सा दे रहे हैं। अब क्या दे रहे हैं, कितना दे रहे हैं, वो अलग बात है। अगर हम किसी मजबूरी के तहत दूसरी शादी करते हैं, बीवी हमारी करप्ट हो, बीमार हो या औलाद नहीं पैदा हो पा रही हो, तो हम उसकी इजाजत, पहली की इजाजत से दूसरी शादी कर रहे हैं, तो आपको क्या परेशानी है? अब दूसरी शादी क्या हो नहीं रही है? हिंदू धर्म में नहीं हो रही, सबसे ज्यादा तो हिंदू धर्म में हो रही है। तो ये कानून से इसलिए लाए जा रहे हैं कि वोट पोलराइज करो, हिंदू मुसलमान कर लो।
भाजपा के नेता ये भी कह रहे हैं कि अगर 2 बच्चों का नियम है और अगर हिंदुओं पर लागू होता तो बाकी सब कम्युनिटीज पर, स्पेशली मुस्लिम पर क्यों नहीं लागू होना चाहिए?
देखिए, अगर सरकार ऐसा कोई कानून बनाती है तो हमें क्या एतराज है? ये इसके लिए कोई हिदायत हमें शरीयत से थोड़ी मिली है।
Cutting across to my colleague Arunima, who is with us on the broadcast. Arunima, any key takeaways from the bill? That's the copy that we have put out for our viewers. You can see that in the middle of the screen right now. That's the text that has been presented on the floor of the House. The exclusive details here on CNN News 18. Arunima, tell us what more we can know.
So I've just received the PDF copy of the bill, Anusha. We only saw 182 pages being circulated to all the members of the Legislative Assembly. But after that, there are 20 more pages of explanation. So the total, 202 pages is what this, PDF takes into account. The first 182 pages are about the various parts and detailing on the sections. Then comes the annexures. So total 202 pages is what the legislators have to read through. The main portions of it I have already highlighted. It's a bill which has been divided into 4 parts. If you recall, the committee that had given the recommendations had also given 4 volumes of their recommendations, and this also bill takes each of those into account. Part 3 deals with live-in relationship, Part 2 deals with divorce, Part 1 deals with marriage, and the last part also deals with inheritance rights. I've already highlighted to you how the bill is dealing with the issues of polygamy. If you have a spouse alive, you cannot marry now in Uttarakhand if this bill is passed. So polygamy is now outlawed. Once this bill is passed, tribals are being kept out of the purview. Live-in relationship, you will have to register, and most importantly, I'm just reading out Part 3, Section 378 and 379. Children of a live-in relationship, any child of a live-in relationship shall be a legitimate child of the couple. So the child will enjoy legitimacy, which so far was bestowed only if you were born inside a marriage. So that is, some would call it progressive, but here on the streets of Uttarakhand, a lot of people across communities had objection to this, but the Dhami government is proposing under the Section 379 of the Uniform Civil Code that the child born out of a live-in relationship be considered legitimate. There are also provisions made on how the live-in couple should go ahead and register themselves with the local authorities. The other provisions about which this bill talks about is about how the marriage will happen, and it says that other social customs like nikah, Anand Karaj, Saptpadi, so all the religious customs, you can marry under those, but you can also marry just under the civil code, making it a civil legal marriage. Sum total of what I have managed to read through so far.
That's the sum total of what we've been able to pick so far. What one needs to see, as I earlier said, Uniform Civil Code was never about doing away with the practice of nikah or the saath phere or the Christian wedding ceremony or a wedding ceremony that you see in a Gurudwara. It was always about ensuring that once the wedding ceremony is over and it's legally a marriage, the rights within the two parties are equal. So, for example, under the Christian Marriage Act, the divorce period, the mandatory divorce period is still about 2 years, which is very different for other communities, including the Hindus, the Jains and the Sikhs, which are governed under the Hindu Personal Law or the Hindu Marriages Act. Right now, under the Supreme Court judgment, one can even waive off the mandatory 6-month period if the court is convinced that there is an irretrievable breakdown of marriage. On adoption, there is inconsistent laws that prevail. Is there any rationalization of those laws that has been done? One needs to understand that Uniform Civil Code often is spoken in a tone and tenor which is deeply political in nature, but this has been a pending legal and constitutional work in this country, keeping in mind that a good part of our life is governed by the sphere of personal laws. And if those personal laws do not respect the right to equality, Article 14 under Indian Constitution, then what kind of country we've really created? Dr. Bhimrao Ambedkar, who was the architect of Indian Constitution, had actually envisioned a country where not just criminal laws but also civil laws were actually uniform in nature. This entire bigamy of the civil versus the criminal law was created in this country as something that we got out of partition. It was a hangover by the British. The 1937 Shariat Application Act is actually an act that was put in place because Muslims wanted to secure their customary practices and ensure that they are not governed by the Hindu personal law. The fact that it was under in the year 1937 tells you that this is a pre-independence era law. The argument for a uniform civil code is an argument of civil rights and gender parity. What is the method and means by which the government is really doing that is a political question. Have all parties been consulted? Have all stakeholders really spoken to each other? Are the concerns of the community really taken into account? And what is the manner and means by which, say, two very important practices under the Muslim personal law that need to be outlawed? One is marriage of girls under the age of 18. That should not be permitted. That's voidable marriage under the Child Marriage Act and various other statutes. The second bit is about polygamy, which theoretically and legally is still permitted. One may argue that it doesn't happen very often, but the fact that you can legally do it in this country is a problematic proposition. Polygamy in many ways has been outlawed or has been made extremely difficult and impossible even in Muslim countries. So what is really the argument for a practice like that to survive in India? So those are the two facets to watch out for. When it comes to divorce, especially under Muslim personal law, it's a customary practice again. There are 4 to 5 methods by which Muslims divorce each other. The process is largely oral in nature. You can give a written notice. Triple talaq is completely outlawed by the judgment of the Supreme Court, and in fact has been made a criminal offence. I want to cut across back to Arunima and get in a word from her about what are the other tidbits that she's been able to get after reading through this particular legislation or the piece of draft that has been presented before the Assembly right now. Arunima, what more do we know right now?
Yes, so registration of marriage or divorce is a crucial section here. This is sections Chapter 2, Section 6 onwards. It is making registration of marriages compulsory. So that's there, I think, even otherwise, under the Marriage Registration Act, if you get married under the Special, Marriage Registration Act, you have to register. If you get married under the Hindu Marriage Registration Act, you have to register. But now this is being made uniform, to which some people who practice the Muslim personal law have argued that we have our own system of registration of nikah and registration, even if a talaq happens, a divorce happens, it is a contract between two people, and therefore there is paperwork involved. But this Uniform Civil Code is making it, and the officer, there's a full section on how the sub-registrar will be appointed, how the decree of marriage will be dealt with, how the decree of divorce will be dealt with. So that's Chapter 2 that deals with marriage, and then Chapter 3, restitution of conjugal rights and judicial separation. Section 21 and 22 gives a detail about how two people can separate, or if they want their conjugal rights reinstituted.
All right, so just elaborating on the point that Arunima highlighted, and it's a very important point when it comes to the Uniform Civil Code, is the compulsory registration of marriages. It is something that was recommended by the Law Commission earlier under Justice B.S. Chauhan and even the commissions before it. It is also something that has been reiterated obiter dicta in various judgments of the Supreme Court. It is often argued that, look, polygamy is outlawed under the Hindu personal law, but a lot of Hindu men have more than one wife. How can you do away with that practice? You can do away with that practice if there is compulsory registration of marriage. What is compulsory registration of marriage? I am married, and if I have not gone ahead and at the local magistrate office, if I have not registered my marriage within the stipulated time, then there is a penalty that applies, and after a certain point, I would be liable for far more penalties if I do not register my marriage. To get my passport, to get my documents with my spouse as a name on it, that will become far more difficult. Compulsory registration of marriage is the beginning of the Uniform Civil Code. If you want to end polygamy legally and also anecdotally across all religions, across all communities, then the state must have a record as to who has married whom. Polygamy is a reality, and with the kind of migration that we see around the country, there was also an argument there should be a central register that governs the marriages, and there's a record of the manner in which people are conducting about their personal life. In fact, the same is being thought about the land records as well. So compulsory registration of marriages, even legally, is something which is the easiest thing to do for any state. There are various states which are encouraging new couples to come forward and register your marriages as a legal mandate. If Uttarakhand goes ahead and does that, it will be a very positive step. And in fact, this is something which is not even open to any kind of challenge. The fact that this is a voluminous bill, that means the government is well aware that it's going to be a tricky task. Before I go back to Arunima, some more reactions for you.
सर, उत्तराखंड ला रही है यूनिफॉर्म सिविल कोड, कैसे देखते हैं आप, क्योंकि बहुत सारे लोग विरोध कर रहे हैं इसका?
देखिए, यूनिफॉर्म सिविल कोड ये देश हित में है, राष्ट्र हित में है, और मैं कहूँगा कि उत्तराखंड पहला राज्य होगा जो पास विधानसभा के अंदर हो जाएगा, बड़ी आसानी से पास होगा। लोगों में चर्चा है, लेकिन बड़े आसानी से होगा, आएगा। जिस कमेटी ने ये ड्राफ्ट तैयार किया है, उसने सभी समुदायों को पूछ करके किया है, चाहे मुस्लिम हो, ईसाई हो, हिंदू हो, सभी को, और सभी लोगों ने, अच्छे स्तर का पढ़े लिखे लोगों ने इसको स्वीकारता दी है, तब जाके ड्राफ्ट की बात की।
और बहुत सारे मुसलमान जो संगठन है, चाहे MIM हो, चाहे बहुत सारी पार्टियां, वो भी ऑब्जेक्ट कर रहे हैं। क्यों ऑब्जेक्ट करें, आपको क्यों लगता है?
देखिए, कुछ राजनीतिक पार्टियां तो राजनीतिक रोटियां सेकने का काम कर रहे हैं, अपना वोट बैंक की बात है। दूसरा, यदि मुसलमान को इस तरह के बिल्कुल कट्टरपंथी की मैं यदि बात करूं, तो आज भी वो लोग बाहर के देशों से प्रेम करना, ये सारा जो दिखता है, खाना यहाँ का, रहना यहाँ का, सब कुछ सुविधाएं यहाँ का लेना, लेकिन बात करना फिर दूसरे देश का। तो मैं तो कहता हूँ यदि ऐसे कट्टरपंथी तो फिर उनको वहीं चला जाना चाहिए, वहाँ से। हमारा कहना है कि जब हिंदुओं के लिए कानून 2 बच्चे 3 बच्चे, तो क्यों नहीं उनके लिए भी होना चाहिए।
My colleague Arunima with us on the broadcast. Arunima, I was trying to go through the section which is about marriages and dissolution of marriages. And as you highlighted, it very categorically states that the scheduled tribes or the one under the 6th schedule of the Indian Constitution are not going to be covered. No such exemption has been given to the Muslim community. And that in itself states that once this comes into force, it will apply to all communities consistently.
Yeah, I'm just going through, Anusha, so forgive me if I'm glancing at my phone constantly.
Sure, please go ahead.
But I'm just looking at, under the list of, this is the list, Schedule 1, list of prohibited relationship. List 1 actually gives you point number 16. You can't marry your son's widow. I mean, to any educated person, this might look like a no-brainer, but in Uttar Pradesh and in rural parts of Uttar Pradesh, a few cases had come up in the past where a son's widow or son's wife was forced to marry after rape. So there were some instances of this nature where the daughter-in-law was forcibly married to the father-in-law after a rape incident had happened. So I think that is the reason why this kind of a list of prohibition has come up in Schedule 1, and I'm just going through it, and it also goes on to...
And Arunima, one of the reasons that the list of prohibited relationship is there is because under the Hindu personal law and also under the Muslim personal law, there is a list of prohibited relationships. Hindus call it the Sapinda relationship, and Muslims under which marriage to certain individuals is haram. And if you want to bring in a uniform civil code, you will have to have certain degree of rationalization about the degrees of prohibited relationships across community that has been defined. And I believe this particular legislation just consolidates that list that has been scattered all around.
Yes, and it's quite an exhaustive list that they have drawn. So we will have to wait and see how society accepts it. Mostly people that I have been speaking to say that this is coming from within the society itself. As education is spreading, as awareness is spreading, people are doing away with what was once acceptable. But their contention also is that allow the society itself to come up with these changes, allow the Maulanas and the Maulavis to educate. Because that's the language of Hadith, the language of Shariat is what most backward Muslim men and women understand. So allow the community leadership, the religious leaders to come up as agents of change rather than force it as a law from above, because that might be counterproductive. So that's one voice that I've heard, one view that I've heard from the ground. But I think the committee in its wisdom recommended, and Pushkar Singh Dhami government has decided to include those recommendations in this Uniform Civil Code of Uttarakhand.
All right. So, if I try and understand the bare bone or the caricature of how this bill is, it's a 300-page bill, but how does it operate? The fact that at the start, the bill states that this is going to apply to all the residents of Uttarakhand and even the ones who are residing outside. Uttarakhand is a hill state. There are special land rights that exist in Uttarakhand. Nobody can just go and buy land there. It's in a way regulated by the state about who's buying property, who's renting property in the state of Uttarakhand, because it's a conserved area. It's called the Devabhumi. Now, the fact that there is a law in place which says that all the residents of Uttarakhand are going to be governed under this particular code, something like already exists in the state of Goa, that has its own set of problems. Now, the Muslims have not been exempted. What does that mean? That by a simple corollary or by a simple extension of common sense, it means that all the residents living in Uttarakhand, whether Muslims or Hindus or Sikhs or Christians or Parsis, will be governed under the civil code that has been presented. There is no law that says that Muslims are allowed to marry 4 times. It's something which Quran or the Shariat allows them to do. The fact that the Muslim customary law is preserved and protected under the 1937 Shariat Application Act, and a lot of thinkers argue that this is particularly the act that was the basis of division of India in the manner in which culturally we have seen in this country. There is no democracy in this world. There is no democracy or a modern democratic system in this world that allows a parallel verse of personal laws like it exists in India. It is appalling for a country like India, with its jurisprudence, with its laws, with the UN conventions that we are a signatory to, that Article 14 or the right to equality does not apply in the sphere of personal laws. Now, if that does not apply, there is a reason why the courts have not been able to extend that argument, because that somehow has always been linked to the minority rights in this country, and the minorities have been very conservative when it comes to the reform of their personal laws. across the world, it's difficult for the minorities to reform. But now the argument is that we need to rationalize these laws. If polygamy is outlawed, which is already outlawed for most communities in the country, for all communities in the country, barring the tribals and the Muslims, and tribals are exempted and Muslims are not, that means polygamy and the fact that it's outlawed in the state of Uttarakhand will apply to Muslims also. I don't want to get into the argument about whether this is amenable to legal challenge. We'll wait and watch, but this is a welcome step by the Uttarakhand government. Of course, the devil lies in the detail, and we'll have to wait and watch what exactly the details are which are emerging. But two critical aspects. Arunima, once again coming back to you, you pointed out about the uniform age of marriage. It's only under the Muslim personal law that a girl attaining puberty can be legally married. And the second about the aspect of polygamy. Two very troublesome aspects.
Yes, and you know, polygamy, I just spoke to Muslim women and men yesterday itself, and they were telling me that polygamy was made a part of Muslim personal law, made a part of their customs to ensure that women who were destitute, who needed, you know, economic somebody to take care of them economically, for those people to get the right to live an honorable life in society, polygamy was brought in. But if you ask them whether they would you know, completely be against polygamy in this day and age, when they're educated, there was no direct no coming in from this group of women. There were mixed answers coming in. So I think that is what this UCC will disallow. It's very clear, once again, to read to you from part 1, which deals with marriage and divorce. Section 4 is the section dealing with marriage, and it is very clear that you cannot marry, you cannot enter into a contract of marriage if your spouse is alive. That's section 4, subsection 1 of the Uniform Civil Code of Uttarakhand. It says that you cannot get married again if your spouse is alive. And section 4 part 3 is actually saying that a man has to be of the age of 21 and the woman has to be age of 18 years. The parties are not within the degrees of prohibited relationship, and the marriage is not prohibited under any law in force. Those are the 5 conditions which have been listed, because based on which marriages can take place here on in Uttarakhand. Polygamy there very clearly, section 4 subsection 1 being disallowed.
All right. In fact, bigamy, forget polygamy, is an offence in this country. It's a punishable criminal offence. Arunima getting us all the details on that very important story, also getting us all the exclusive details from that draft that has been presented on the floor of the House. This remains at our focus here on CNN News 18. UCC perhaps will set the stage for yet another political debate in the run-up to the big Lok Sabha elections. Slipping into a very short break. Stay tuned.